Good evening, friends. Welcome to today's session on uh, another important topic from the point of view of polity in general studies paper. Why this particular topic, citizenship, is more important, uh, particularly in this year's exam and perhaps for the next year examination also, because this is a topic which has been being very hotly discussed. It has been in news for various reasons, good as well as bad. Uh, there have been, lot of critical analysis of whatever has happened recently with respect to the question of citizenship. That is why I consider this subject, this particular topic, as very important from examination point of view. Of course, for knowledge point of view, we must understand that to know the uh, term citizenship, to know the term citizen, and how this particular status is required for various activities under the provisions of the Constitution, and particularly with respect to fundamental rights and fundamental duties. Because there are certain fundamental rights, as we will see during the course of today's session, where there is a need for being a citizen. I mean, there are certain rights which are not available to non-citizens. So that is why this particular topic has become very important. And there are other related issues like, National Population Register, National Register of Citizens, then, the Citizenship Amendment Act of 2019. All these, have become very, very important from examination point of view, not only for prelims, but also for the general studies mains paper with respect to polity. Of course, I have covered this topic in greater details in my earlier session, which has been recorded and is available on YouTube. But that particular session was keeping in mind the requirements of the law optional paper, whereas today's session will be more simplified in the sense that we will not be referring to many case laws, we will not be referring to many provisions in detail of the Citizenship Act or the other provisions of the Constitution, starting from Article 5 to 11. Now, having discussed, let's quickly have a recall of our journey so far. We started with the concept of Constitution. We moved on to the making of the Constitution, salient features of the Constitution, and the Union. So this has been our journey so far. Today, we are moving on to part 2 of the Constitution. Yesterday, we discussed about the Union under part 1 of the Constitution. Today, now, we are moving on to part 2. Again, I am reminding you that those who have attended the earlier session or have seen the video on YouTube, please do not feel that we have scaled down the length of the topic or the contents of the topic. That is not the intention. It has been done purposely because we want to cover this particular topic, not keeping in mind the syllabus of the law optional paper, but from the polity part of general studies paper. So let's start with this main topic. This is the citizenship under part 2 of the Constitution. Now, what is the meaning and significance of citizen and citizenship? Now, generally, when we look at the dictionary meaning of citizen, it is a person who belongs to a particular state. He is living there permanently or with the purpose or with the intention of permanently belonging to that particular state. So that has been given a dictionary meaning like that. There is no definition of citizen as such given in the part 2 of the Constitution. No definition has been given, so we will have to derive this definition, keeping in mind the various aspects of citizenship with respect to the definition of a state. Now, why we call them full members? Full members means basically it is the intention which is more important in determining whether a person is a citizen or not. His sense of belongingness, he may be born there or may not be born. There are other manners of getting citizenship also. A person need not be a born citizen. We will see during the course of our session that under what circumstances or under what provisions somebody can get the citizenship. But the purpose is to see how a person wants to belong to a particular nation or a state. He should be fully a member of that state. That means should have permanently settled there or has the intention of permanently settling down in that particular state. So, as far as India is concerned, now when we look at the definition of a state, how a state emerges, I am trying to make it very simple for you to understand what do we mean by state. State has got certain characteristics. The first characteristic is that it should have a territory. A state cannot be a virtual concept. State must have a physical territory. Now, this territory should be surrounded by certain boundaries. That means there should be a definite, extent of that territory. Next comes the people. Without the people, there cannot be any state. If there is a piece of land, a piece of territory which has got certain boundaries which are clearly demarcated, but there are no people to live there, so it will not be covering the definition of the state. Now, when we come to here, I am saying, and they should be sovereign. This definition of sovereign we have discussed many times, but for those who are joining new, it is like having no control. They should have complete independence of taking their own decisions, right? So these are some of the characteristics of a state. Here we are talking about the people when we talk of citizens. So citizens are these people who belong to this state. Okay, they should physically belong to that state, Maybe sometimes they go out for different purposes, but they have the intention of belongingness and settling down or taking that state as their permanent residence. Second is, when we talk of people who are coming from outside, now outside means those who are citizens of the other countries, other states, other nations. Merely if they visit our country, will they become the citizens? No. But those are the people who are coming and staying here maybe for some time. Those who may be coming here for tourism purpose, for the purpose of studies, or even for employment. But they have no intention of staying here in India as a permanent. They don't belong to India, or they have no intention of settling down in India. So they cannot be, taken as or given the status of a citizen as you and I have. Okay? So this is the important thing, that they should be the full members of the state. So when they belong, so how the belongingness comes? They owe allegiance to the state. That means they should be faithful to the state. They should not have the intention of betraying the state. It's like your own house. Will you steal anything from your own house? No. Will you play any mischief with your own house? Will you put it on fire? Will you do anything, activity which is illegal in nature? Or you try to destroy your house? No. For us or for citizens, country is like their own home. So that allegiance, that belongingness has to be there. Now they must have all civil and political rights. Why this is important? Let us divide it into two parts, the civil rights and the political rights. And then question comes, let us first understand what are the rights. Now I tell you, again I go back to a simplified definition of our own home, the four walls of our home. When we are staying in our own home, whether we own it or we don't own it, but we are there, physically we are present there, we have an intention to stay there permanently. We have built up, we have contributed our labor, our efforts, part of our life, we have contributed in building up that home. Now, in that home, when we are living, we must have certain rights. The right to privacy. Okay, you must have freedom to stay. Nobody should disturb you. You should be having safety. You should keep your belongings there and nobody will disturb that. So all these certain kinds of freedoms. Now you link this example with that of the state, your own nation. So when we are taking our nation as our home, we must be given certain rights. Rights of peaceful living, rights of having certain kinds of freedoms, right to life and personal liberty, right to profess or propagate our own religion of choice. So in all those rights are now available in two forms. One is the fundamental rights and other is the legal rights. What is the difference between the two? Now, fundamental rights are enforceable. The state to which we belong owes us certain rights. It is a duty cast upon the state to provide those fundamental rights which are very much essential for our peaceful existence and living. And those are basically fundamental rights and can be enforced. Now, other than the fundamental rights, there are certain rights which are given to us by laws. Okay, like we can take the example of, let us say, the right to property. Now, it is not a fundamental right. It used to be earlier. Now, it is a legal right under Article 300A. So, what is the status of the legal right? Yes, they are also enforceable, but not in the sense of fundamental rights. Because there we have access even to the Supreme Court under Article 32. But for legal rights, for their enforceability or for in case of any violation of those legal rights, we have other forums. That is, the other courts are available. Recourse to judicial system, recourse to getting justice is available, but not in the same manner as it is available in the case of fundamental rights. So, these are our civil rights, fundamental rights and other legal rights by which have been given to us by any law. It may be constitution or it may be any other law. Now, when we talk of the political rights, what are those political rights? The political rights are that we can fight any election, we can hold any political position, we can belong to any political party of our choice. And the most important is the right to vote. I should not be stopped from voting if I am an adult and a citizen. An MLA or a MP has to be a citizen. President of India has to be a citizen. So these constitutional authorities, the first requirement is being a citizen. That is the importance of being citizen. That's the significance of citizenship. Now, these rights are not available to aliens. Aliens, as in my previous lecture also, some student has asked me, what is an alien? Again, I'll clarify that. Alien is who is not a citizen, who is an outsider, not belonging to that place. Alien, please do not take it in the negative meaning only. That means alien doesn't mean that that person is hostile to us. As we see in the movies, aliens coming from Mars or from other planets or space. No, they are different kinds. They may be aliens. I mean, we have not seen them. We have just imagined that. But in the case of a state, aliens are those who are outsiders, who do not belong to that place. Now, aliens could be friendly or aliens could be our enemies also. So, alien means an outsider who is not a citizen but need not be taken in a negative aspect. The first thing is they do not possess any civil or political rights. They are given only those rights which are, considered as essential for being a dignified human being. That is why when we say, again I go back to the definition of law, what does law do to us? It gives us rights and it gives us certain amounts of duties. it casts upon us certain duties or responsibility. Further, in these rights, there are two types. One is which are basic for existence, which are required for protection of our existence as a human being. Those rights can be taken as under the caption of protective rights. And there are certain rights which come in the form of what? They give us certain privileges. So they give us privileges. What is the difference now? As I said, protective rights are those which gives us certain kind of protection. Like as a human being, I must be given a dignified life, a dignified liberty in various forms. Personal liberty, it could be liberty of moving around and should be like not to be arrested for without following the procedure established by law or by due process of law. My personal liberty should not be taken away because any human being, whether he is a citizen or a non-citizen, he may be a visitor to our country, he may be an alien coming from outside, but he also is a human being, and being a human being must be given those protective rights. And that is why these protective rights, even under the Constitution, have been given to non-citizens also. Right to equality or equal protection of laws. 20, 21, 22. Now these are some of the rights, fundamental rights, which are available to even non-citizens. Why? The reason being, they are protective rights. They cannot be arrested illegally. They cannot be, when they are under detention, they have been given certain rights. And the right to life and personal liberty is also given. So these are available to all persons. Now we come to privileges. Privileges is the prerogative of only the citizens. Privileges are given only to the citizens. I give you an example. Suppose we are traveling to, let us say, Australia. Now, if I go there and I am going there as a student, let us take that. I am doing my studies. I am looking for an employment. I do not get the employment. I do not get any job there. A citizen of Australia will be getting what? An unemployment allowance from the government. Whereas I, being a non-citizen, will not be getting that. If I fall ill, I will not be given free medical treatment, whereas the citizen will be given. So those are the privileges which are available only to the citizens. Now we take the privileges under the Constitution of India, like freedoms under Article 19, Article 15, no discrimination, Article 16, no discrimination in employment, in public employment. So, a non-citizen or an alien cannot claim those rights. This is the difference. So, they do not enjoy all the civil rights, whereas we as citizens will get all civil as well as political rights. The aliens will not. So, aliens, I said, they can be friendly or there can be enemy aliens. Enemy means when we have given the status of enemy to any other nation. Now, these are some of the rights which are available to citizens but not to aliens. Article 15, I said no discrimination on the basis of caste, race, sex, etc. That is a general non-discrimination. Article 16 is with respect to what? Is with respect to employment in public offices. So, it is available only to citizens. Article 19 are the 6 freedoms, only available to the citizens. 29 and 30 are certain privileges given to the minorities. Right to vote is available only to citizens. Right to contest elections is available only to citizens. And eligibility to hold certain public offices, which I mentioned, like even when you become an IAS officer, a civil servant. The first condition is that you should be a citizen of India. You want to join the armed forces, you have to be a citizen of India. You want to contest and become a representative of the public in the form of a MP or a MLA, become a minister or even president of India or hold any other office, election commissioner, controller and auditor general, etc. There are so many public offices which only the citizens can hold. Now, they also have certain duties. That's what I said. Law gives us rights as well as imposes certain duties on us. Now, what are those duties which we owe to the nation? We have to pay taxes. We have to respect our national flag, national emblem, national anthem, national song. These are duties cast upon us. In addition to that, these are just few examples. When we talk of we right, etc., there are others also. What are those duties like? We have fundamental duties under part 4A, Article 51A. Now, what are those fundamental duties? I am talking only of citizens. I am not talking of directive principles, because directive principles are the duties or responsibilities of the state for its citizens. See the difference. The fundamental rights are to be ensured by the state and they are enforceable. They may be available to citizens or they may be available to non-citizens also. We have seen a few of them. But directive principles are the duties cast upon the state. Because as per law, there must be duties also. And as far as fundamental duties are concerned, they are cast upon the citizens. Like some of them, we have said that respecting national flag, national anthem, etc. We should have fraternity, we should have unity and work towards the unity and integrity of the country. We cannot ask other countries' citizens to do these duties for us. These duties are cast upon the citizens only. Like we have president. Now, this is a very typical example, very interesting to note that in the case of India, how liberal we are and how large-hearted we are, that to be president of India, you have to be a citizen of India. But what will be the mode of getting that citizenship? should that person be only citizen by birth? No. In the case of India, he can be citizen by birth as well as by naturalized citizen. What is the naturalization process? We will see later on. But see, there's a wider scope. But in USA, to be president, you must be a born citizen, citizen by birth only. So what are the constitutional provisions for the today's topic, citizenship? It is from Article 5 to 11 under Part 2. I have already mentioned that. There are no permanent or elaborate provisions. That means there are certain provisions which, leave certain things to the parliament. That parliament can make laws to regulate citizenship as to who is eligible to become a citizen and who is not, who can be deprived of citizenship. That means the state, by law, we can stop, we can say, if you are a citizen, you will be deprived. You will not be given the citizenship of India. You are from elsewhere. Or confer citizenship on that person, on some person, provided the provisions of that law are fulfilled by that person. If they meet those conditions, they are eligible to become the citizens. Otherwise, the state may also say, your citizenship is terminated. So, these provisions are not definite. They can, relate to many issues which keep on changing. The latest being the Citizenship Amendment Act, which has brought certain new provisions which we will discuss later on. But it's a dynamic process. Citizenship is granting, non-granting, what conditions is a dynamic process, and how that process is carried out is by way of parliament making laws which relate to or regulate citizenship. So, the main act is the Citizenship Act of 1955. So, when we will study administrative law, you will see that there are two things. One is an act or a law, which is the main law. Then there are rules framed under that. Under that act. Now, these are in the form of delegated legislation. We will study when we study administrative law. But for your understanding, you must know that there is a main act and there are certain rules which are framed under that, within the purview of that act. Okay, they cannot go beyond the purview of that act. Whatever is provided in the act should be the technical issues, the processes and minor details of its implementation will be in the form of rules. So, similarly, as far as citizenship is concerned, we have a Citizenship Act of 1955 and the rules framed under this act. Now, Constitution of India has given 4 categories of persons as citizens on January 26, 1950 when it came into force. One was at the time of Constitution, this 26 January 1950, who were domiciled in India. That means, what do you mean by domicile? Those who are living there. So, as on that date of Constitution coming into force, those who were domiciled They were citizens, they were treated born, they were treated as citizens whose parents were born or who were residents for 5 years prior to January 26, 1950. Now, second category is those who migrated to India from Pakistan. Now, here you will say that India got independence on 15th August 1947. And Pakistan, when it came into, their independence day is one day prior to that, that is 14th August 1947. Why this difference of day? Because it was, we gained independence on the midnight of 14th and 15th of August 1947. And there is a time difference between India and Pakistan by how much? 30 minutes, half an hour. So when the midnight strike was there was stroke of midnight in Delhi, in India. It was still 14th August in Pakistan. That is why they celebrate their Independence Day on 14th August. So we say, okay, we became independent on 15th of August 1947. The Constitution came into force on 26th January 1950. So between 1947, August 15th and 26th January 1950, during this period, lot of people migrated from Pakistan to India and vice versa. So those who migrated to India with the purpose of settling down here, they were to be given the status of a citizen. That is why this category was created, migrated to India from Pakistan. This another category who during that period migrated from India to Pakistan. But they came back. There were certain people. So they were also treated provided they met certain conditions. Persons of Indian origin residing outside India. Now these are the people like who have their origin, whose parents, grandparents, etc. were citizens of India or were born here in India. But they have been living outside India in other countries. But they are considered as persons of Indian origin because their roots, their origin, their forefathers, their ancestors, they were from India. So but they shifted, or the parents might have shifted, and their children were born, let us say, in UK. So the children became citizens of UK by birth. Suppose I take one example, like my parents, suppose, had they shifted, migrated to, let us say, USA or UK. Now, in that case, and I might have been born there. So, I would have got the status of a citizen by birth of UK or USA, as the case may be. But now I want to get my Indian citizenship because of my ancestral connections. So, in that case, persons of Indian origin who have been residing outside India, they are also given a choice of getting Indian citizenship provided they meet certain criteria. Like they get registered with our consulates or our embassies in that country, and they have an intention of becoming an Indian citizen. So these are some of the conditions, but primarily you must remember these are the 4 categories. Now, what does Citizenship Act deal with? It deals with acquisition and loss of citizenship. It basically regulates the concept of citizenship. as far as India is concerned. Now, originally there was a concept of Commonwealth citizenship, but it was repealed in the year 2003. Now, how one can get citizenship of India? Primarily 5 ways. By birth, very simple, is born there. By descent, that means the parents or the grandparents might have been born here. Registration, certain categories, they have to register. Naturalization, that means certain laws permit them to become citizens. And then incorporation of territory means, suppose India gets another territory. We take again the example of Sikkim. Sikkim was a separate nation. Its territory got incorporated in the territory of India. So, the citizens of then Sikkim, they became the citizens of India by way of incorporation. Let us take one by one. By birth, certain categories are there in this also. Between 26 January 1950 and July 1st, 1987, if they are born irrespective of the nationality of his parents, that means if they are born in the territory of India. Now, I tell you one very interesting example of territory also. Territory does not mean that only the land territory. Suppose somebody is flying or traveling by a ship which is carrying Indian flag and born there, they get a choice to become citizen of India by birth. So, they should be born. Now, it is irrespective of the nationality of their parents. Parents may be even, belonging to any other nationality, except in the case of diplomats. We'll see that. And the enemy aliens. Now, after July 1st, 1987, a condition has been put. Why? I'll tell you the reason. Only if either parents is a citizen of India, either the mother or the father at the time of birth. Why this 1987? Because we got independence in 1947 and 30 years is generally one generation. So within that 30 years, if one is born, automatically by birth, they get the citizenship. But after 1987, 1st July, one of the parents, either two or at least one of the parents, should have been a citizen. Now, after December 2004, only if both of their parents are citizens or one is citizen and other is not illegal migrant. Why this problem? Why this changing of scenario? First we have seen is obvious, there is no problem. Second is also not a big problem. Third stage is a problem because of the problem of illegal migrants. Now, who is an illegal migrant? Just I'll touch upon this. We have a separate slide on that. But illegal migrant is one who has come with not legal papers. What are those legal papers? Either the passport or second, if any, visa requirement is there. Either they have come without that or they have come with the valid documents, but those documents have expired. So they become illegal migrant, either without papers or with papers, but those papers have expired. They have no validity. Children of foreign diplomats, I told you, even if they are born here in India, they do not get the citizenship by birth. By descent, after January 26, 1950, but before December 10, 1992, if his father was a citizen at the time of his birth. Now, what do you mean by descent? We will not be studying the family law because that is outside our syllabus. But when we talk of descendants, it is from the father's side mainly. When we talk of ancestrals, we generally do not talk about the maternal side, but we talk of the paternal side. So we take the father's citizenship at the time of the birth. After December 10, if either of his parents is a citizen. So descent after a certain time period of 42 years, this condition is now applies if either of his parents. Earlier it was only the father because of the descent. After December 3, 2004, if they are not registered at an Indian consulate within 1 year of the date of birth. So that suppose they are born outside, but they have to be registered with the Indian consulate. So by registration, when we talk of registration, the first thing which comes to us is that the citizen who is getting the citizenship not by way of birth or descent, because that is the kind of automatic getting citizenship. But here that person is now acquiring citizenship. So when we acquire citizenship, you remember in the beginning itself we said we must have allegiance to the state. So the person who is a newcomer, new entrant as a citizen must do one thing first. What is that? That he should take oath of allegiance to qualify to become our citizen. Persons of Indian origin plus resident for 7 years. He should be a person of Indian origin plus a resident in India for 7 years. Married to Indian citizen plus resident for 7 years. These are the conditions for getting citizenship by way of registration. Minor children of the citizens. A person of full age whose parents are citizens. Overseas, citizens of India for 5 years. This term we will see in detail. So these are some of the conditions to get the citizenship by way of registration. By naturalization, the basic condition is they are basically regulated by law. That's how they naturalize to become a citizen. They are not, this process is not available to an illegal migrant. Conditions are not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens. Suppose there's another country which does not permit Indian citizens to become their subjects or their citizens by way of naturalization. It is a reciprocal process. If they allow our citizens, we will allow that country's citizens to become our citizens by way of naturalization. Naturalization, I am again saying, is regulated by laws made from time to time. So they must renounce the citizenship of the other country. They must give up that. Because why? We have system of single citizenship. We don't have dual citizenship under the provisions of the Constitution. So, resided in India or been in service of a government in India for at least 12 months. These are few conditions. Good character, language in the 8th schedule they must know, oath of allegiance to the Constitution of India. Okay, so like for registration and for naturalization also, we must have this condition because this is the primary condition or requisite for being the citizen. Incorporation of territory, I have already explained. If any foreign territory becomes a part of India, the government specify who among those people shall be the citizens. The government may put certain restrictions that this section of the people will not be taken as our citizens. So it is again regulated, even if the territory is incorporated into India. Yes, somebody wants to ask?
Yes, sir.
Yes.
Please explain the language of 8th schedule.
8th schedule, I'll tell you there are certain languages which have been listed. Okay, I'll just open that Constitution of India and then refer to some of those, we'll refer to the 8th schedule here. There are schedules in the Constitution, 9 schedule, so we'll refer to the 8th schedule. Fourth, sixth. That is why I always say, whenever we study law, we must have the concerned act, bare act with us. We have 7th schedule and now we have the Yeah, 8th schedule is here. These are some of the languages which have been listed. A. Assamese, B. Bengali, then Bodo, Dogri, Gujarati, Hindi, Kannada, Kashmiri, Konkani, Maithili, etc. So there are 22 languages which have been listed in the 8th schedule. So one of these languages should be known to that person. Is it okay?
Yes, sir. Yes, sir.
Thank you. Thank you. So, let's proceed further. Now we come to a typical situation which had come in, which occurred in the state of Assam. Now, Assam has got a typical problem of, illegal migrants particularly from Bangladesh, and prior to formation of Bangladesh, it was the East Pakistan. So, there was lot of problem between the locals and the illegal migrants because the border being porous. When we talk of porous borders means even if you have lot of security, there are certain ways where the illegal migrants can enter or can cross over without being checked. Okay, there is no fencing or kind of obstructions to control their movement. So in this case, in the case of Assam suffered a lot because of that. So all persons of Indian origin who came to Assam before 1966, this was one of the conditions which was incorporated in the Assam Accord. Now came to Assam on or after the January 96, but before March 25th, 1971. This is very important date. March 25th, 1971. Why? See what happened in 1971. That time Bangladesh was not born. Bangladesh was born only in December 1971 after its liberation by the Indian forces and Mukti Bahini. Now, in the month of March, there were elections in Pakistan. That time, Bangladesh used to be East Pakistan and there was West Pakistan, as we have now, whatever is left over of the Pakistan on the western side. During that election, in East Pakistan, the party led by Mujibur Rahman won the elections. They got the majority. Whereas in the West Pakistan, the other parties won. Now the question came as to who will become the Prime Minister or the President or head of the state. So the East Pakistanis, they said that they will have the Mujibur Rahman as the head of the state. Whereas it was not acceptable to the West Pakistan. That is where the whole problem came. And on 25th March 1971, they declared the independence of Bangladesh. They said, Mujibur Rahman is our leader, is head of the state. And because of that, the problem started, which ultimately led to formation of this particular date, when they declared the formation or independence of Bangladesh, the West Pakistan people, they started committing atrocities on the people of East Pakistan. Worst kind of atrocities. And because of that, there was an exodus of refugees in India. And most of them, they went to other states also, like West Bengal and Tripura. But the most of this brunt was felt by Assam. So that is why this date is very important. They said those who came to Assam after January 1st, 1966, but before that, because after this date, so lakhs of people, they migrated from Bangladesh to India and particularly to Assam. And most of them didn't go back. That is why this whole problem aggregated. Now, how we can lose the citizenship? There are three ways to lose the citizenship. One is renunciation, that is, we give up on our own, terminated under the law, or deprived by law, that so and so cannot become. Now, renunciation should be full age, means adult and has capacity, mental capacity. Minor child also loses Indian citizenship, provided his parents will do that. Renunciation during a war withheld by the central government. That means if somebody renunciates there is a war between India and any other nation, and during that war period, if renunciation is there, then it can be withheld because of the certain extraordinary or special circumstances. So the central government can withhold that renunciation and say, no, you should not renounce. Now, termination. When Indian citizen acquires citizenship of another country, that means when I go to some foreign country, let us say to Malaysia, and I take up the citizenship of Malaysia. In that case, as per Indian Constitution, we should have only single citizenship. So I'll have to, my citizenship of India will be terminated the moment I become citizen of another country. But it will not apply during the war. As I said, it's a very special circumstance, an extraordinary situation. Deprivation is compulsory termination. That means you will be deprived of your citizenship. Under what circumstances? If the citizenship has been acquired through fraud, disloyalty to the Constitution, unlawfully traded or communicated with the enemy during a war, that means we act as a traitor, within 5 years after registration or naturalization, been imprisoned in any country for 2 years, gone to other, not by way of birth, but by way, if I become a citizen, by way of registration or naturalization, and within 5 years of my becoming such citizen, I go to another country and commit an offense and I am imprisoned for 2 years. Then I will be deprived of Indian citizenship. The citizen has been ordinarily resident out of India for 7 years continuously. Okay? So if I am residing in some foreign country outside India for 7 years continuously, I have not come back, I can be deprived of my citizenship by way of compulsory termination. Constitution, federal and dual polity, center and states, but citizenship. Now, what is this? Our Constitution has got a federal structure. I have been explaining again and again, and for those who have joined us now, we have a federal system, federal structure, where the units have not joined by way of any agreement, but they have merged into one union. Even yesterday's session, we have discussed this in detail. So we have a dual polity, that means we have a central government and we have the governments in the states. Now we have a dual polity, but citizenship is single. This is a feature of our Constitution. So single citizenship is our main feature as far as citizenship is concerned. USA, they have double or dual citizenship. That means they can be citizen of that particular state as well as the citizen of America. If somebody is a citizen of Florida state, he can be a citizen of Florida also and also citizen of America, United States of America. So that's a dual citizenship. Now, Indian citizens, I have already said, enjoy all equal civil and political rights. Now, what are those exceptions? There are certain exceptions. Now, that is the exception of domicile. Sometimes, by law, a state government may say, under Article 16, that residence within a state or union territory as a condition for certain employments, that only those who are residing in that particular state or union territory shall be eligible for employment, certain employments to public offices in that particular state or union territory. This we will study in detail, but for the time being, just remember these are some of the exceptions. Under Article 15, it does not prohibit discrimination on the ground of residence, means state can provide special benefits or give preference to its residents. Again, because Article 15 deals with what? Non-discrimination on the basis of residence. But by law, certain categories can be given certain privileges in that state, maybe in the form of reservation. A particular community, maybe Jats, maybe Muslim, but by law, not by their own declaration. So this much has been guaranteed under our constitution. We will discuss this in detail when we study Article 15 and 16. 19. Freedom of movement and residence subjected to the protection of interest of any scheduled tribe. In tribal areas, there are by law some restrictions on the movement of even the citizens. Even I cannot go, or you and I cannot go to certain tribal areas, maybe in Car Nicobar, because of there being some endangered scheduled tribes living over there. Now, Overseas Citizenship of India, OCI, this is what I referred earlier, OCI. Now we will see what does it mean. In the year 2000, a high-level committee on Indian diaspora under the chairmanship of L.M. Singhvi. What do you mean by diaspora? Diaspora is the people of Indian origin who have settled abroad outside India. They form our diaspora, Indian diaspora. Okay. Then they recommended grant of dual citizenship to the persons of Indian origin. Now there are different terms, OCI, PIO, persons of Indian origin. This is another category. We will have a comparative study in one of the subsequent slides. Then Citizenship Amendment Act 2003, acquisition of overseas citizenship of India, OCI, by PIOs. That this OCI status may be given to certain PIOs, persons of Indian origin. These were through the amendments to the Citizenship Act of 1955. First, this amendment of 2003 gave this. Amendment of 2015 of recent amendment merged PIO card and OCI card, and we have now only one card, that is the Overseas Citizen of India OCI card holder. Earlier it was either you are having a PIO card, person of Indian origin card, or you have a Overseas Citizenship of India card. But now these two have been merged and now we have one single card, Overseas Citizen of India card holder. What are the advantages of this? Earlier, even persons of Indian origin, if they wanted to travel to India, they had to apply for a visa. And like others, suppose somebody is a citizen of USA, he wants to travel to India. Prior to this, he had to take an entry visa and permission to stay, and other restrictions were also applied. So OCI is not a dual citizenship. Please, let us make it very clear, because they may ask you a question on this. If a person is holding a OCI card, will it not amount to dual citizenship? No, it has been barred. That Article 9 forbids dual citizenship, and OCI is not giving them the citizen status. Now, citizenship registration of OCI card holder, it provided under this amendment of 2015, conferment of rights on OCI, certain rights were given to them, renunciation of OCI. It was also that earlier OCI card was to be renounced, and this OCI card, and they had the choice of renouncing this also. Cancellation of registration as OCI, a provision was made under this amendment. Just remember these four features of this amendment. These were the four provisions made under this Amendment Act. So, who will get registered as a overseas citizenship of India card holder? Certain kinds of qualifications have been added through this amendment. Any person of full age and capacity, full age means being an adult, who is a citizen of another country but was a citizen of India at the time of or at any time after commencement of the Constitution, that is after 26th January 1950. That means at the time of commencement or after that, who is now a person who is now a citizen of another country, but prior to that, he was a citizen of India. Who, or second thing is, who is a citizen of another country, but was eligible to become citizen of India at the time of commencement of the Constitution. Okay? Eligibility. He is meeting all those eligibility criteria. If special circumstances exist, central government may register a person as an OCI. So, central government has been given certain kind of discretion, provided there are certain specified special circumstances. Conferment of rights. What rights are there? Not be entitled to the following rights. These are exclusions. Right to equality of opportunity in matters of public employment, that means under Article 16, not given to them. Not be eligible for election as president and vice president. Not be eligible for appointment as a judge of the Supreme Court and High Court. No registration as a voter, cannot vote, cannot become MLA or MP, and not for appointment to public services like ours, civil services. Now, renunciation. If a person ceases to be an OCI, spouse and minor child also cease to be OCI. If I give up my OCI card, if I am an OCI card holder, I give up that. So, my family, that means my wife and my children, will also cease to be the OCIs. Cancellation of registration as OCI card holder by means of fraud, false representation. If they get the OCI card by fraud or by false representation, disaffection towards the Constitution. See, I tell you, I am again and again telling, we go back to our first slide that there must be allegiance to the Constitution of India, faithfulness, our sense of, nationality, our belongingness. All these are the characteristics of becoming a citizen. So, faithfulness or allegiance to the Constitution is a must, because Constitution is the supreme law of the land. Now, within 5 years after registration, being sentenced to imprisonment for a term of not less than 2 years. Even an OCI card holder, if he gets this kind of punishment, his OCI will be cancelled. Marriage dissolved by a competent court of law. The marriage is, dissolved by any competent court of law there, the OCI can be cancelled. Now, here is a matrix which shows different characteristics which will distinguish them. How? NRI is one, non-resident Indian. Indian citizen ordinarily residing outside with an Indian passport. Now, earlier, if we look at the PIO and OCI, they are citizens of the other country. They are holding passport of other country. But if an Indian passport holder is residing outside India, he will be treated as a NRI, not as PIA, that is not as person of Indian origin or overseas citizen of India. Now, person, ancestors, Indian national, but now citizen of another country. His ancestors might be citizens of India earlier, but now that person is a citizen of another country. OCI card holders under Citizenship Act. We have seen that. So, OCI not eligible for persons whose parents, grandparents, citizens of Pakistan or Bangladesh. This condition has been put for OCI because, whose parents or grandparents are citizens of Pakistan or Bangladesh, they will not be given OCI card. So, all benefits as India, as an Indian. No specific benefits are under PIO, but certain benefits like entry, multiple entry, lifelong visa, parity with NRIs in most cases. In few cases, that has been withheld, but generally, if a OCI card holder has to travel to India, there are no visa restrictions. No visa is required for NRI. PIO, yes, visa is required, but can visit India without a visa for lifelong. Need to register with local police if stays more than 180 days because he is a citizen of another country, not a citizen of India. Though his origin may be Indian, but he is no longer citizen of India or he is not a citizen of India, but OCI has been given another status and this will not apply to OCI. Now, this is important from examination point of view. The CAA, that is the Citizenship Amendment Act of 2019. What are the salient features? Just remember here, for detailed study of CAA, kindly go through my session, which is already recorded and is available on YouTube. If you want a link, we will send you the link. Now, Hindus, Sikhs, Buddhists, Jain, Parsi and Christian, these persons belonging to any of these religions, illegal migrants from only three countries, Afghanistan, Bangladesh and Pakistan, they are primarily given the eligibility to become Indian citizen. Remember these religions and three countries. Okay, this is for your remembrance. I'll tell you the background also. Why? Illegal migrants we have already seen, without proper documents or with valid documents which have become invalid. Why this only three countries and why these religions? You see, these three countries are not secular countries. They are what? They are Muslim countries. There, the state religion is Islam. So, Muslims are in majority in these three countries. So, automatically, these six religions become what? They become minorities. Right? So, majority community is Muslims, but minority communities are these five. So, but what is India's religious characteristic? We are secular country. There is no state religion. We give respect to all religions. There is no discrimination on the basis of religion. This is the principle of secularism, which is there embodied and enshrined in the Constitution of India. This is our greatness. But whereas in these three countries, which were, if we look at the historical background, they were at one point or the other part of a larger India. But then they became separate countries: Afghanistan, Pakistan, Bangladesh. And there the majority is Islam. Majority religion is Islam. These religious denominations are all minorities. This is first condition for eligibility. But main thing is that they have been persecuted. Very, very important. What do you mean by persecution? See, there are two words, prosecution and persecution. Prosecution, what happens in that? Somebody has committed an offense. Now, under the laws of that land, if the person has committed an offense, he or she can be prosecuted as per the provisions of that law. Prosecuted. Prosecution means if you have committed an offense, you can be prosecuted or, can be proceeded against under the laws. The laws of that land. Laws of land. Very important. Whereas in the case of persecution, you might not have committed any offense. No offense under the laws of that place, laws of that land. But still, you are treated badly. You are tortured, you are discriminated. And certain atrocities are committed against you. Even though you have not committed any offense, you have not broken any law of the land. Still, because you are in minority. So this persecution is at the hands of the majority. So when there is a persecution by majority over the minority. Now, this does not happen in the case of a secular country. This happens only when there is a state religion and that religion is enforced by the state. That certain restrictions are put on the minorities communities. Either the religious places are desecrated, destroyed, they are prevented from performing their religious functions, etc. Their appearance or any other thing. They are not allowed to, celebrate their religious festivals. So these are all part of persecution. So previous requirement was that the applicant must have resided in India during the last 12 months as well as 11 out of the previous 14 years. That means prior to this amendment, a person belonging to these religions, he is an illegal migrant from these three countries, But, I mean, he is meeting all these conditions belonging to these religions, illegal migrant from these three countries. So prior to this amendment, what was the condition? He must have resided in India for 12 months in the last 11 out of 14 years. I think it should be very clear. Out of 14 years, in 11 years, and the condition is in the last 12 months must have resided in India. Now, after this amendment, the second requirement, that is that of 11 years, has been reduced to now 6 years. This is a kind of a privilege given to these persecuted minorities from these three countries. So constitutionally, the present position is that the constitutional validity of CAA, that is this amendment of 2019, has been challenged in the Supreme Court of India and the outcome is still awaited. It has not yet been decided by the Supreme Court. I have already mentioned the meaning of illegal migrants: enters country without valid papers or with valid papers stayed beyond permitted period. So, but under this amendment act, now they will not be treated as illegal migrants if they are from these three countries, have entered India on or before December 31, 2014. These are the new amendments through this Amendment Act of 2019, are not in certain tribal areas of Assam, etc., or under the inner line permit, that is Arunachal, Mizoram and Nagaland. So what are these? They are not in the tribal area. This is condition. Tribal areas of Assam, Meghalaya, Mizoram or Tripura in the 6th schedule of the Constitution. Okay, we just now refer to 8th schedule, which mentions about the languages. Now this 6th schedule mentions about the certain tribal areas of these 4 states. Or there is an inner line permit which is required for Arunachal Pradesh, Mizoram and Nagaland. Now, what is National Register of Citizens? These are some terms which you should know because they are in news. NRC is an official record of legal Indian citizens. Now, when we talk of legal Indian citizens, it includes those Indian citizens who are staying outside India also. All Indian citizens, wherever they may be. So here, National Register of Indian Citizens, the register containing details of Indian citizens living in India and outside India. Okay, I said there are rules made under the Act. So this is the Rule 2K of the Citizenship Rules of 2003. It was first prepared in 1951 following the census of 1951. Census, I'll just tell you. Let's first finish this. In 2003, under Section 18(1) and 18(3) of Citizenship Act, the central government made the citizenship, these rules. Okay, I told you about the Act is the main act, rules are framed under that, and it provides for a nationwide NRC. Now, this is census. Census means enumeration of the population of the country. Head count, each and every person of the country has to be counted. Census. It is conducted in an interval of 10 years. The first census was conducted in 1872 and the census next year, 2021, will be 16th census. This is important because next year you will be writing this examination. and that will be the census year. So please remember, next year this will be the 16th census, first census in 1872. And after independence, it will be the 8th census. Okay? Now we come to special provisions in the state of Assam regarding NRC. It is not being enforced in whole of India. Only in Assam it was implemented, or it was, applied. It was enforced in Assam because to resolve the problem of illegal migration from Bangladesh and the neighboring regions, so that identification and deportation of illegal migrants can be done. Just remember this. This is not the right forum, time to get into these details, because this is a separate topic itself. If we get into that, we need a separate session. But for examination point of view, just remember this. Now, Rule 4A of 2003 rules says it deals with the special provisions of NRC in the state of Assam. Says house-to-house enumerations is replaced with invitation and receipt of applications from citizens of specified particulars. That enumeration, not like a census, but applications will be invited and received. Then status is given under this 4A based on NRC of 1951, 51 census, and electoral rules up to the midnight of 24th March 1971. Same, the date when the exodus began, 25th March exodus began. So, up to the midnight of 24th March, this was to be considered for determining the citizenship. So, provides for inclusion of original inhabitants of Assam, that is, for on whom there is no doubt about their citizenship. The manner of preparation of NRC in the schedule of, it is given in what manner this NRC was applied in the state of Assam. It is given in the schedule of these rules. Now there is a foreigners tribunal. If somebody is aggrieved by the decision of the authorities for inclusion of their names in NRC, they have a appeal. That appeal lies with the foreigners tribunal. Within 120 days, this appeal has to be filed. The persons with their names excluded in NRC can appeal to foreigners tribunal within 120 days. So this is a appellate provision. Now we come to National Population Register. This is different from National Register of Citizens. How? It is a register of usual residents of the country. It covers the entire population, head counts, but their NRC is meant only for the citizens. It includes both Indian as well as foreign citizens at that particular time, at the time of enumeration, those who are living in that particular area. What areas we will mention. So it is the official record of legal Indian citizens, this NRC. This is the difference. It covers only Indian citizens, that too legal Indian citizens, and whereas it includes foreign citizens also. So what is the population register? The register containing details of person usually residing in a village, rural area, town, ward or demarcated area. Demarcated by whom? By the Registrar General of Citizen Registration within a ward or a town or in a urban area. Basically, it covers the entire territory, whether it's a units in the form of units, whether it's a village, a ward, a town, or a municipal area. So, like this, NPR is being prepared at local village level, at sub-district level and district levels. What is sub-district? Is the subdivision. It's a part of district. See, when you will become IAS officer, your first posting will be the sub-divisional magistrate. You will be heading the administration of a subdivision, state, and then at the national level. It is mandatory for every usual resident of India to register in the NPR. So, what is a usual resident? According to these rules, a usual resident is a person who has resided in a local area for the past 6 months or more. This is the time. If a person has resided in an area for minimum 6 months or more than that, then only his name will be added in that. Or a person who intends to reside in that area for the next 6 months or more. Here the keyword is the intention to stay. So friends, with this, we have come to an end of today's session on this topic of citizenship as covered under Part 2 of the Constitution, the Citizenship Act of 1955, and various terms like NPR and NRC, the important CAA of 2019. We have purely gone through the text and the provisions of these, registers or the rules or the amendments. I'm again telling you, when it comes to the answering of questions, please stick to the provisions as they exist on the statute book. Text. Please refrain from giving your own personal views on any of these issues. If anything is asked in the question itself about critically examining a particular issue, you can give both the sides' views. The views what are in existence and what are the criticism. And then finally wind up on a positive note that this is the factual position. If we say CAA, and we can finally conclude that the validity of this provision is pending before the Supreme Court of India for a final decision. Unless it is asked, you are asked to critically examine, please stick to the facts and the provisions of that statute. Okay, so with this I conclude. Any issues, any clarifications, any questions, queries, please. Yes.
Yes, sir. I have 2 questions.
Okay, one by one, please, because I don't have anything to write. Yeah.
Yes, sir. When you mentioned about the deprivation of Indian citizenship,
Yes.
in the case of Indian nationals, Indian citizens, you mentioned disloyalty to the constitution is one of the grounds on which
Very right.
it can be deprived.
Very right. Yes.
And when it came to OCI, the point was saying disaffection towards the constitution. How are these determined? What are the thresholds of disloyalty or disaffection to the constitution?
See, these are some issues like, very, very subjective. Subjective in the sense that if you are intentionally abusing any part of the Constitution, or you say, yes, I have no faith in this Constitution, or you say something which is contrary to the provisions of the Constitution, it will be taken as if you have no faith in the Constitution. See, you may have doubts about anything, like if suppose you are not able to understand any particular provision of the Constitution, you have a doubt which can be clarified, or either by the legislature, or you can go to a court of law and say, okay, see, what is the interpretation? This is the job of the judiciary. If suppose I have got it, I am a OCI holder, or I am a citizen whose citizenship is being deprived or denounced by the central government on the grounds that I have no faith in the Constitution, or I have abused the Constitution. Now, if I have used any abusive words, derogatory words against the Constitution, I have definitely violated that. But if it comes to any, like I have a doubt about the provision of the Constitution, then the court of law is there. There is a provision for interpretation. But if I know and willingly and intentionally I abuse that part of the Constitution and say, I don't believe in this. So, go to hell if you don't believe. What are you doing in India then? If you don't have faith and belief in a Constitution of India, which is the supreme law of the land, then why you are here? Why you should be the citizen? Why you should be given the privileges of a citizen? So, for us as citizens of India, supreme law is the Constitution of India. And we must have allegiance to that. If we do not have, leave. You don't have any right to be citizen. What's your second question, please?
So the second question is just what I read somewhere on an article. I read this that when the CA was just passed, and it said that whenever there is a group of people coming from a certain country, if the intelligence officer, if the intelligence agencies rep like that somehow, that they can pose a danger to national security, that it is beyond judicial scrutiny.
No, it is not like that. See, any action on the part, any legal action, which is as per the provisions of the law, cannot be merely based on the intelligence inputs or merely on a report given by any intelligence officer. See, I'll tell you my own background. I have worked in CBI for 5 years before joining the IAS in 1987. I was a CBI officer from 1980 to 1985, 5 years. Now, of course, I was not part of Intelligence Bureau, but I have seen working of the intelligence agencies very closely. We used to work in tandem. So, no action can be taken merely, see, intelligence reports and the intelligence officers, any adverse comment is only a guiding factor. Merely based on that, no action can be taken unless the provisions relating to that particular actions are fulfilled as per the provisions of the law. Nothing, if suppose I am a citizen, if some intelligence officer writes against me that he has done this or he has, abused the Constitution, that can be one of the inputs that can be, taken as an evidence, but not the conclusive evidence. The procedure established by law or the due process of law has to be followed before any adverse decision is taken. So, merely based on intelligence reports, this cannot be done. This is illegal. If it has been done, it can be challenged in any court of law.
So, for example, this was a video case I identified. When we talk about, let's say, Rohingya, for example, providing them with citizenship, if the intelligence agencies rep like that, is it still under judicial scrutiny?
Yes. Every action of the executive is subject to judicial review. Yes, it cannot be made public or it cannot be discussed in public, but if the judiciary demands it, any agency, including the intelligence agencies, will have to provide that to the judiciary. That is why sometimes you hear that even in Supreme Court, certain reports are given in sealed cover because they are not to be made public. Because now suppose if I am red flagged by any intelligence agency, and some action is taken against me, I can go to court, appropriate court. And then that court will decide whether due process or the procedure established by law has been followed or not, whether the action of the executive is just, reasonable and fair. If it is not, it will be treated as arbitrary decision. And arbitrary is antithesis to rule of law. We are governed by rule of law, not by the whims and fancies of some people or even intelligence agencies. Every action is justiciable and can be challenged. But how and what procedure will be followed is the discretion of the judiciary.
Okay, sir. Thank you.
Welcome. Welcome. Yeah. Yes, please.
Hello, sir. Can you explain the difference between naturalization and registration?
See, registration, I'll go back to that slide again. Yeah. See, by registration you mean, one of the condition was that if any person of Indian origin is living abroad, okay, now what happens is they have an intention of getting Indian citizenship. They are not citizen as of now, as of today, but they have intention. So now what they have to do is they have to go, they must have fulfilled this condition and they must be registered. They must be registered with whom? If they are abroad, with the Indian consulate. That is by way of registration. Or they must come here, or if they are staying in India, they must get registered with an appropriate concerned authority as per the Citizenship Act and its rules. So that is by way of registration. And one condition of that is to have the oath of allegiance. That is part of the registration process. But in the case of naturalization, he should not be illegal migrant, number one. Naturalization is by way the government permits, they pass the laws and they permit certain categories of people to become Indian citizens by a naturalization process, but not by way of registration. Registration is when you register with an appropriate authority as provided under the rules. And you must be a person of Indian origin or any other category which is falling under this, whose parents are citizens like that. But naturalization, any person, whether he is a person of Indian origin or not, a foreigner, or whose parents, etc., or no lineage, no connection with the Indian citizenship, he is totally an alien. But he wants to become a citizen of India. For that, there are a separate provision, that is as per law. So this is the basic difference between registration and naturalization. Is it okay?
Yes, sir.
Thank you. Thank you. Yeah. So friends, if there are no further queries or questions, I'll wind up. We'll meet tomorrow with a new topic. which will be conveyed to you at the around the same time. And till then, all the best. Good night.
For more videos, subscribe to BN by IAS and press the bell icon to never miss an update.